All right, good afternoon, everyone. My name is Kathy Purdy. I'm the marketing manager here at Schoeneck King, and I'd like to welcome you to this week's Tuesday webinar series. Just two quick housekeeping items before we get started. Please enter your questions through the Q&A box located at the bottom of the screen. We do have a really packed program for you today, so we will do our best to address those as time permits. Once the webinar has ended, if you would take a moment to complete the survey, we would appreciate that. We do share your comments and suggestions for future topics with our presenters. So to get our program started, I'm going to hand it over to Andy Bobrick.
Great. Thank you, Kathy. Welcome, everybody. Very good to have you with us here today. We've been using a lot of baseball analogies internally here, getting ready for this one. I got to tell you, we got an all-star lineup today. It's going to be a great presentation, and we've got a lot of good content for you. We want to start things, and I wish we had a lively discussion as we were just waiting for this to get ready here, and we had to be reminded that the program was going to start. There's a lot going on right now. I know there's a lot on your plate. You're monitoring the news like we are with respect to the positive changes that we're seeing here in New York, and with respect to the CDC as we start to loosen up restrictions further. Want to start by having our reporter on the ground in Albany, Katie Anderson, give us an update about what's going on right now. She's been tracking things very closely. I think I've talked to you 5 times, Katie, in the last 12 hours on various matters, which is always great. But what's going on?
I've spoken with you more in the past 12 hours than I have to my mother, so she'll be upset about that. So I apologize, Mom, if you're watching.
Sorry for you.
I'm sorry. I'll call you later tonight. Yeah. So looking at what's happening in New York, before we get into the big news, we're going to start where we always start. What's the data showing us? Cases continue to drop. This is great news. I am thrilled to see that our cases are, close to where they were last May, hoping that we keep continuing on that downward trend. Currently in New York, and there are different numbers coming out from the governor's office than there are coming out from the CDC about how many people are fully vaccinated in New York. Total individuals vaccinated in New York, it's 43% are fully vaccinated. 52% have received 1 dose. Now, if you're looking at just people who are over 18, half of the adult population in New York State is fully vaccinated. As of yesterday, it was 52% of New Yorkers who are over 18 are fully vaccinated. So great news. And that leads us to what everyone's talking about, what I see all the questions coming in about are likely about the change in mask guidance. So as you can recall from the last webinar, I had alluded to there's a good chance that in the next month or so, the CDC is going to be changing their guidance about face masks for fully vaccinated individuals indoors. And that announcement came much sooner than any of us thought it was coming. But here it is. This announcement was a surprise for everyone. The White House, in fact, was notified only on Thursday morning that this would be happening on Thursday afternoon. So throughout all of this, just know that there's still lots of unknowns here. We are working through it. We're being as diligent as we can be, but be patient because not every answer is available yet. So what is the change? Fully vaccinated individuals no longer need to wear their masks or social distance except in certain circumstances. And those certain circumstances are pretty vague, as we can imagine. But what does it mean for New Yorkers? Yesterday, the governor announced that New York will be adopting the CDC guidance beginning on May 19th, so tomorrow. And if you can remember, May 19th is also when we're having all of the changes to capacity limitations. Now, originally, those changes to capacity limitations were removing all percentages from how many people can be in a space at a time. It can be 100% of the people there, so long as everyone's socially distanced. The issue now is that's not necessarily the case anymore. It's changed. And so what does it mean? For fully vaccinated individuals, as long as you're checking, fully vaccinated individuals do not need to socially distance, do not need to have capacity limitations, and you don't need to have them wearing masks. We will be going into way more detail about what that means. Where will masks and social distancing still be required? Let's start there. Healthcare settings, so a hospital, doctor's office, nursing home, schools, specifically pre-K through 12 schools, public transit, homeless shelters, and correctional facilities. That is where masks are still required under state law. Businesses and other places may choose to continue to require masks. We've seen lots of places continue to require masks because, as I'm about to explain, it is complicated as how this order is going to work. What does it mean? There are still so many unknowns. When I did these slides, this was true. The only guidance that was available to us from New York State was a press release. We have now received a new executive order. It's Executive Order 202.108. This executive order is more vague than the press release. So we really still have just the press release to go on with that. What does it mean, though? For the capacity limitations, you may remove the 6 feet of social distancing if all present show proof of their full vaccination status. That's important. The 6 feet of social distancing goes away if everyone can show that they're fully vaccinated. What does New York State consider to be proof of full vaccination? Either your paper vaccine card, a digital application, which remains unclear what that means, or the Excelsior Pass that shows that you are fully vaccinated. Digital application, we've received lots of questions. Does that include somebody who's taken a photo of it of their CDC card and has that photo on their phone? Really unclear at this point. Remains to be seen what they mean by digital application. Our best guess is that they mean another app that's like the Excelsior Pass app, not a photo of the card. So keep that in mind for when those things pop up. But again, we hopefully will have more guidance on this within the next week. If someone's vaccine status is unknown or they are not vaccinated, the 6 feet of social distancing still applies and they still have to wear their mask. That is important. Remember the baseline rule for your offices and every place else. If you're in a meeting and you are 6 feet apart, you don't need to have your masks on. But now, if everyone's fully vaccinated, you can be close together and you don't need to have your masks on. But if there is someone in that room who is not vaccinated, they will need to be kept 6 feet away from everyone else. Erin will be going next and talking about what does that mean and what are the implications of that. One thing to note as well, there are some venues that are only opening for vaccinated individuals. Radio City Music Hall was on the presentation with the governor yesterday and announced that they would be opening in June only for fully vaccinated individuals. There are certain implications there of public-facing businesses, places where you have visitors coming in. And again, that's going to be Erin's up next, and she'll be talking all about it. Looking at what this means for events. Fully vaccinated individuals may attend events at 100% capacity. Masks are optional. So like we were talking about with the Mets and the Yankees, you'll have these sections of stands that are fully vaccinated sections, and it will look like a regular baseball game. And then you're going to have sections that will be unvaccinated, and everybody will have to be groups of people will be kept 6 feet apart. Finally, unvaccinated individuals don't have to be socially distanced, and children, who have not been vaccinated have to be seated with their vaccinated adult, even if they are, unvaccinated at an event. But, there's really two key things to remember here. One, I just ask that everybody be patient. We don't have all the answers yet. The state doesn't have all the answers yet. Guidance is changing every hour at this point about what applies and what doesn't apply. So just, kind of take this week with we're just going with the flow this week. And then, the second thing is guidance will be coming. We don't know when. So keep in touch with your favorite attorneys. They'll let you know what's happening. And with that, I'm going to kick it back to Andy.
Katie, thanks a lot. Yeah, the pace of the change we're seeing right now is reminiscent of, a year ago, more than a year ago, when we were dealing with these things hourly. So thanks, to folks too. This is something we're staying very close to. Aaron Porcello, who I'd like to welcome next, is going to drill down a little bit more on this from the perspective of employers, businesses, organizations, and try to look at some of the practical issues here that are coming across our desk that we're giving thought to. And as Katie mentioned, we're working through these issues right now. Oftentimes, these are our best sense of things, but we are going to continue to filter through the information that's coming out rapidly and do our absolute best to provide you with guidance. I should add too that our presentation today is not intended to replace you contacting your bond attorney and working with them to address your specific issues as well. So Aaron, again, I know we've been talking too over the last couple of days. Thanks for joining us. And what are your thoughts right now?
Thanks, Andy, for having me. And growing up, my parents always said that I had impeccable timing, and my agreeing to do this program yesterday morning at 9 a.m. could not anymore just embody my impeccable timing, as the governor a few short hours later said, hey, guess what? No more masks for vaccinated folks after I agreed to do this program. So everyone, as Andy said, bear with us as we are trying to get our bearings as to what the outline, the guidelines are going to be on this and what the framework is going to be. As Andy said, we've been talking internally about a number of issues that we will touch base upon during my quick snippet here. Some of the things that we're, like you said, giving thought to, and some of the conclusions that we are reaching. One of the first things that I want to mention is Katie had said we just got the executive order this morning, which is even more vague, if that is possible, than the bullet points of what was announced yesterday in terms of this mask mandate or repealing the mask mandate. And an interesting thing that was noticed in the executive order that was released is that it does not actually reference or repeal the executive order that deals with businesses requiring masking of its employees. So we anticipate that that is probably an oversight, and that there will be another executive order that corrects this executive order. But the executive order that's in place right now actually doesn't repeal the mask mandate for businesses. So, but in light of everything we've seen, we think that that is what was intended, and this was simply an oversight, and there will be a correction. So what I'm about to say is in line with what we understand the intentions of the governor's office to be. So one of the things that I think we need to keep in mind as employers, as we're considering what our next steps are going to be in terms of implementing a mask rule in our workplaces, is to keep in mind that not one size is going to fit every employer in this situation. Just as it hasn't fit, one method hasn't fit every employer throughout the pandemic, the rollback of these mask mandates, I think, are going to be the same thing. And what do I mean by that? Well, as you saw, Katie already identified a number of industries that are exempt from the rollbacks of the mask mandate: schools, public transport, homeless shelters, correctional facilities, nursing homes, and healthcare settings. So we already know that there are going to be certain industries that this rollback does not apply to. But even beyond that, you may assess your business and decide that because of whatever field you're in, you may not want to roll back the mask mandate for your employees quite yet. Some examples: large retailers, where you have a number of visitors from the public coming in and out, and you either aren't checking vaccination status, or it's difficult to check vaccination status and you've declined to do so, you may decide that for the meantime, you are still going to require your employees to wear masks because it's just not easy to figure out who's been vaccinated and who's not as they are coming into your place of business. And that's okay. There's nothing, the governor is not saying that a business has to choose to allow employees to no longer wear masks. So you may decide, if you're a retailer, restaurant, hotel, whatever the case may be, that because of your employees' exposure to the public, you want to keep the mask mandate for employees for the time being, regardless of their vaccination status. There may be businesses that, even though there's not a lot of visitors in and out, your employees work in close quarters. And so you have decided that, if you're a manufacturing facility, employees are close, and you don't want to get in the business of repealing back these mask mandates quite yet, that's okay. There's nothing requiring you as an employer to do that. If you are a business that is thinking about implementing a policy rolling back mask mandates, I want to jump into a few of the things that we are thinking about already. Some of the conclusions that we are reaching, although every scenario is going to be fact specific. So as Andy mentioned, please reach out to your labor council to walk through some of these issues, both the legal and practical issues here. So if you are thinking about rolling back your mask mandates for your employees, the first thing you're going to have to think about is, okay, does it make sense for my organization? If the answer is yes, am I going to require employees to show proof of vaccination? There's nothing that requires you to show proof, and you are allowed to ask for proof of vaccination. So you could decide to go the honor system route. There's nothing in the executive orders that requires an employer to get proof. All it says is that vaccination and fully vaccinated individuals do not have to wear a mask. Okay. If you go by the honor system, I would probably suggest that you let employees know that they have to have their proof of vaccination readily available should they be asked for it, either because, I don't know, the Department of Health is there, whatever the case may be. But you don't have to require proof of vaccination if you choose not to. If you do choose to require proof of vaccination, Katie went through, at least with the events, that the state has identified 3 valid proofs of vaccination. It's unclear if that is what's going to be required, because employers are not required to even ask for proof. I don't think that they are necessarily limited by those 3 means. What do I mean by that? I think if you ask for a picture of the card, that should probably be okay for purposes of an employer asking for proof. It may not be good enough to get into a concert venue, but it's probably good enough for your employees to go maskless at work. You can also ask for a copy of the card, or just proof of the card, the Excelsior pass. However you ask for proof, though, you have to think about what you are doing with it after you ask for it. Are you keeping a copy? Are you making a notation of vaccination status someplace? No matter what you decide to do, keep in mind that we really should be treating vaccination status as confidential medical information. So if you're asking for a physical copy of the card, just as we would somebody giving you a doctor's note about a medical condition, I would keep that in a separate secured medical file. If you are keeping a spreadsheet of people's vaccination status, have that password protected. Share that vaccination status only with people on a need-to-know basis. Now, I'm sure every single one of you are thinking, but isn't somebody who's not wearing a mask proof that they are vaccinated? Yes, but we're not sharing that information. If it is a voluntary program or rule that the employee can choose to go maskless if they show proof of vaccination and there's no mandate, I do not see an issue with that setup, even though there is some indication as to what that person's vaccination status is. It's really no different than early on in the pandemic when we were dealing with issues of making an announcement to a department or to a floor or to a business that somebody is tested positive for COVID. And everybody may have been able to identify who that person was. So long as the employer is not, because they're absent from the workplace, so long as the employer is not singling out people and identifying who they are, making an announcement via email or whatever the case may be, even if it's obvious, it's okay. So the other thing I think that we want to do as you develop your policies is have conversations with your employees, not to make presumptions that why that person is wearing a mask or not wearing a mask. So for example, if you have people in your workplace who continue to choose to wear a mask, it may be for any one of a number of reasons. They have kids at home who are not eligible for vaccinations and they just feel more comfortable. Some people are just beginning to leave their houses and have interactions with the public, and they may just feel more comfortable wearing a mask right now. Some people may be immunocompromised, and it's still unclear how well the vaccine protects immunocompromised people. So I would encourage in your policy people not to jump to conclusions or presumptions about why someone is continuing to wear a mask. I would also encourage supervisors and your employees to have informal conversations during meetings, like, how does everybody feel? Are you okay without a mask, or do you feel more comfortable if I wear a mask? I think at this point, we really want to encourage people to be respectful of sensitivities and where people are as we start to roll back some of these mandates. There are a number of other issues that we can get to, but for purposes of saving time for others to speak, I'm going to turn it back to Andy for our next speaker.
Erin, thanks a lot. And yeah, Erin, thank you for joining us on short notice today. Everybody should know Erin and I go way back. We started at the firm together as summer clerks. So I felt it would be hard for her to say no once I made the ask. But here's the other thing. I'm going to do it publicly now, Erin. Will you agree to come back next week if you can, just to do some follow-up on this for us?
If I have to, I suppose.
Okay, all right. Well, we have a lot of questions. Erin, you covered almost all of them. Some of the things we're getting, and just correct me if I'm wrong here, is do we still need to do the daily screenings for our employees? Do we still need to have our infection control plan in place?
Yes.
And again, yes, those are still on the books. They haven't had changes there. So maybe more to come on that, but for now, that's the guidance that's out there. So thanks again, Erin.
No worries. Thank you.
All right, so shifting gears slightly, but still connected to COVID, it's my pleasure to welcome Jim McGrath here today. Jim joined us as part of our combination with the Putney Twomley firm. Again, one of the, I can't think of a more exciting event that we've had here at Bond. It's great to have Jim with us. We're talking regularly already on a wide variety of issues, and Jim wanted to present it a little bit today on the HERO Act. Again, to all of you on this line, I know you have a lot of balls in the air juggling right now. This is one you need to have in the mix and to stay on top of. But we want to give you some background on this and some issues that we're seeing that are out there. And there were some recent developments here too. Jim, thanks a lot for joining us.
Thank you, Andy, and I'm quite happy to be joining this august panel. This is my first time presenting for Bond, and I'm quite excited about it. So as I believe in prior seminars, you've been informed about having an infectious disease exposure prevention plan. For ease of speaking, I will simply refer to it as an exposure plan. Every employer in New York is going to have one of these in place now by July 4th. It's been pushed back 30 days by the technical amendments that were recently passed by the Assembly and by the Senate. On the slide that you have up here, you can see I've highlighted in green some of the changes that these technical amendments have imposed, and they're actually quite significant. The plan that you have to have in place applies to all sites that are under an employer's control and does not apply to those that are not under an employer's control. What this is really getting at is homework. So you're not responsible to have a infectious disease plan in place for someone who's working remotely, which is obviously good news. And you can see that the requirements of the plan are quite extensive as to what you're going to need to do. PPE, hygiene stations, regular cleaning and disinfecting, all of this is going to have to be in your plan. Now, the good news, as with your site plans, the state is going to issue and publish model plans. And in my experience, I don't know if other panelists feel differently. In my experience, all of my clients adopted these model plans, and it would be the great exception if anyone modified that plan. So the good news is you're not going to have to do a great deal of work, but you are going to have to adopt such a plan. You then have to post it at all sites. Again, this is new. Question as to what does all sites mean? Does that mean in each and every building if you have some type of campus structure? The one clarification that is helpful, you don't have to post it inside of company vehicles, which is good news. Another change, only supervisors can be tasked with the responsibility for compliance with the plan, so you can't put a rank and file person in charge of the compliance with the plan. Obviously, you can't discriminate against individuals for participating in the plan. And they can, though, employees can raise reasonable and good faith beliefs as to conditions being unsafe. What does that mean? They can complain. And there was a great hue and cry that went out that all this is doing is creating another batch of lawsuits that are going to be imposed upon employers. The governor's memo dealt with that and specifically said that he wanted to curb that. So you'll see that the penalties are for fines, private right of action, for injunctive relief. What does that mean? They can stop you from not having a plan, force you to have a plan, and but there are no claim for damages. Why don't we go to the next slide?
Jim, apologies. We don't have your slides loaded. So people pay attention here, no doubt. What we will do is send them out. There's 2 slides, folks. We'll send those out to everybody immediately afterwards so that you have those available to you. But this way, Jim, you have their full attention.
Wonderful.
No distractions.
A court can award costs and reasonable attorney's fees if an action brought by the employee is frivolous. The fees and costs can be assessed against the employee, the attorney, or both. Although this sounds great on paper, getting a New York State court to deem an employee's health and safety concern as being frivolous, I think is going to be very much an uphill battle for employers. But it is good news. This to me is the best news. The employee must give the employer written notice of the alleged violation and can't sue until 30 days thereafter. So if an employee says there's something wrong with your plan, you don't have sufficient controls as to cleaning, and as a result, I think your plan is not in compliance, the employee has to alert you to that, and you have 30 days in which to cure before an action can go forward, unless, of course, you were to be so intemperate as to say, we're not changing anything, in which case the employee can start the action tomorrow. The other good news that it's only a 6 months statute of limitations, which is frankly very short and welcome news. And again, this was all part of the technical amendments. The other thing you have to do as an employer, and this is now effective November 1st, is to have a labor management safety committee. Many of you who are unionized already have such committees. Those of you who are not unionized probably do not, but they are quite common in the union setting. The good news is that if you have such a committee, you can task that committee with compliance and enforcing the rule regarding health and safety. The committee must be allowed to meet at least once a quarter of not more than 2 hours. That's paid time, by the way. You must permit committee persons to attend 4 hours of paid training. The technical amendment did not make clear, though, how frequently that 4 hours of paid training is to occur. Is it once in the employee's lifetime? Is it annually? Or is it also quarterly? Right now, I think you would argue that it's just once for all time for that one particular committee person. 2/3 of the non-supervisory employees have to be selected from rank and file, so you can't dominate the committee from management. And people have a right to attend workplace policy inspections, governmental site visits where permitted by law. There are circumstances where employees cannot attend those inspections. Again, only supervisors can be tasked with the responsibility for compliance, and there's a protection for retaliation for participating on the committees. There's a very interesting, or two interesting issues regarding preemption, whether or not these committees would be deemed to be violative of the National Labor Relations Act as what are called employer-dominated committees. That those are committees that are essentially known as in-house or sweetheart unions and violative of 8A2 of the National Labor Relations Act. That will be hashed out in the future. There's also an argument, I don't think it's quite as strong, that this entire mechanism is preempted by OSHA because OSHA has not sought or not seen fit, I should say, to create these types of committees. I think that's a harder argument, but we have to wait for that to play out. And that's what I had, Andy.
Jim, great. Thanks a lot. Forgive me, I was trying to track down your slides here. One question that we keep getting from people, if you didn't cover it, is what about the model documents from the state? Do we have any insight on those? I know there's a June 4th effective date in there, but that was also impacted by the technical amendments. Is that right?
That's correct. It's been pushed to July now. It's been pushed back 30 days. In the talk that I've heard, most people expect that these model plans will be very similar to the site plans that we already have. And that, as I said, most of my clients followed and frankly appreciated. It would be nice if in the future the government did our work like this for us and at least came up with model plans that we can tweak if necessary. But it's now July 4th. But what employers need to remember is once the plan is published, the model plan is published, you're going to have 30 days to then adopt a plan, whether it's the model plan or your own. And then you have to publish that, give that out to your employees.
Great. Thanks, Jim. So good news there, folks. We got a little bit more breathing room on this for what was going to be a near impossible deadline, all things considered. We'll continue to monitor this. We'll get more guidance out. Rest assured, when we see more news from the state on this and any model forms, you'll be the first to know. I'm sure it'll be a subject here of our webinar. So thanks again, Jim.
Thank you.
All right. Next up, another all-star we have from our team here, Nihla. Great to have you with us. Nihla is going to talk a little bit about some of the vaccination issues. And a question, I think we probably got 30 of them was, can I mandate vaccinations? Some nuance on how you go about that. I know this is an issue that you've been following closely and had some things that you wanted to report on today. So thanks for joining us.
Oh, thanks, Andy. So with all of the good news that Katie shared today, it's kind of really tempting to mandate all of your employees to kind of get vaccinated. But like all good things in life, it comes with a few things that you need to consider. Let's turn to my first slide. So the Washington Post recently did a poll, very recently in March 2021, and they polled some healthcare workers and workers in the healthcare sector, and 42% of healthcare workers oppose mandating the COVID-19 vaccine, and 30% of those healthcare workers either intend to decline the vaccine or were undecided. And almost 75% of that group indicated that they would sacrifice their jobs, quit, rather than being vaccinated. 30% of non-healthcare workers oppose mandatory COVID-19 vaccine policies. So those are kind of daunting statistics. Keeping that in mind, I figured we'd talk a little bit about how you would go about, if you wanted to, implementing a vaccination policy or a program. Next slide, please. When we consider some of these implementation considerations, we want to look at reasonable accommodations and what does that mean? And we've talked at length in these webinars about those areas and some of the logistical considerations of vaccine administrations and what happens. Every program should probably have a consequence. Do you discipline employees? Do you terminate employees? What does that mean? And what are some of the recent developments or guidance around that area? I think one of the most important questions we've had is, well, can an employer mandate a vaccine? Sure. I mean, the EEOC kind of indicates that yeah, an employer can mandate a vaccine. However, it is subject to exceptions and a lot of other nuances that we do need to consider when we do so, or when we make that decision to do so. So let's move on to a really quick kind of overview of reasonable accommodations. And in terms of, next slide, please. Thanks. So we have those medical-based and religious objections that employees pose. Employees may say, well, you know, I have a disability that prevents me from being vaccinated. Or they could say that I have a religious belief or practice or observance that prevents me from being vaccinated. And an employer really does need to consider that, engage in a flexible, interactive process to identify what some of those workplace accommodations are. But here's kind of like the key takeaway that I kind of want to talk about today is that your managers, your supervisors, they are your front line kind of point of communication. And it is important. I know we're doing all of these changes and lots of things are going on, but it's important that your managers are trained to recognize a request for accommodation and know to whom the request should be referred to. And it's also important that they need to know that it's unlawful to disclose an employee's reasonable accommodation or retaliate against that. So it's very easy in casual conversation to say, oh yeah, person X could not get vaccinated because, but that would be putting you kind of in that danger zone. Next slide, please. So even if an employee cannot get vaccinated because of their disability or sincerely held religious belief, it might be lawful for the employer for you to exclude the employee from the workplace, but this does not mean that you can automatically terminate an employee as a reasonable accommodation may exist. The standard to prove that there's undue hardship and that you cannot accommodate an employee is really high. So you want to make a good faith effort to be really sensitive to that need for accommodations. As an implementation tip, one of the things that I like doing when formulating vaccination policies is really consider developing a forum for kind of having an employee make that request, because it gives you time and a supervisor also a mechanism to say, okay, well, here's the vaccine exception request form. Why don't you complete that? And we'll talk a little bit about what some of your concerns are. And that kind of really helps ease some of that process and get the information that you're looking for. Next slide, please. So what are some of the logistical considerations of that? And I think I have a few items that I wanted to select. And this is basically off of, next slide, please, off of the EEOC that provides some guidance on requiring employers who are considering requiring its employees to be vaccinated against COVID-19. So one of the concerns is, well, is the vaccination considered a medical examination for the purposes of the ADA? The EEOC says, no, the vaccination itself is not a medical examination. However, if you have received the vaccine, when you do, prior to receiving it, there are these pre-screening vaccination questions, and those may implicate the ADA provision on disability-related inquiries. So for example, say you have the vaccine being administered on-site, or you have a contractor that you direct the employees to go to, who acts on behalf of you. In those instances, there is that area where you do have to consider that it may implicate the ADA. And then there are also questions on so say your supervisor says, hey, I'm fully vaccinated. Are you vaccinated? And the employee says, no, I'm not. And then the supervisor goes, why not? And then the employee proceeds to then disclose information on someone's disability or genetic history, which then also puts you in that danger zone in terms of the ADA. So questions such as asking why an individual did not receive a vaccination is a no-no. And you want to inform employees not to provide any medical information as part of their proof of vaccination. And I know we've talked a lot today about, let them provide a proof of vaccination. But if some employees are overachievers, so we'll provide you the vaccination card along with their medical history. And you kind of want to be able to outline a scope for that in your policy or your vaccination policy or program. Next slide, please. Of course, there are exceptions to these standards when the vaccination is offered on a voluntary basis. Any pre-screening disability-related questions that you ask also are must be voluntary. And if the employee refuses to answer the pre-screening questions, the employer would say, well, I decline to administer the vaccine. And in all circumstances, you can't retaliate against, intimidate, or threaten the employee for such refusal. And there are also instances where you direct the employee to receive the vaccine from a pharmacy or other healthcare provider that you as an employer has not contracted with. So in that instance, that works as well. Those are exceptions to the standards. I also wanted to quickly touch on, next slide, please, OSHA guidance. There is some OSHA guidance that was recently issued. They're not necessarily advisory in nature, but they encourage that employees be provided a COVID-19 vaccine at no cost. And you can't really distinguish between workers who are vaccinated and those who are not. Finally, next slide, please. The question is, can an employee be terminated for refusing to take a COVID-19 vaccine? We just talked about the general rule to it, but COVID-19 vaccines were approved by the FDA under an emergency use authorization, which has information that it provides the right of individuals to refuse the drug, the vaccine. And a recent federal case actually is, it's being litigated at this moment. And one of the contentions was that there's a memo that employees received where it stated being vaccinated is a requirement and a condition of ongoing employment. This corrections officer was terminated. And at this point, we're kind of waiting on developments as to what that turns out to be. It's an important case that we're keeping an eye on. So to end and conclude, I just kind of like to say that when you should be cautious about taking corrective or disciplinary action against employees who refuse the vaccine. And when, of course, always, I guess you want to make sure that your policy, be it mandatory or voluntary, considers some of these logistical considerations that we've talked about today. But thank you.
Thank you so much. This was great information and a lot of really good detail and helpful things I think that our clients and friends of the firms will be able to take with them. I guess for me, listening to all this, these are weighty, complicated matters, and I think it's evident to those on the webinar here. But again, what we're trying to do is identify these things, help you identify these issues, help you have a framework on how to analyze them. But again, I think it warrants emphasizing that given the ramifications and that, oftentimes we're dealing with legal terms that have nuance that have been interpreted by the courts in different ways in different regions. It's something you're going to want to work with your bond attorney on and engage counsel. Great. Well, thank you again. All right. Last but certainly not least, we're going to run over a few minutes today, but we had a lot of important topics to do, and I think it's worth it. And this one is right at the top of the list too. Welcome Howard Miller from our Garden City office. Howard is one of my favorite people here at Bond, somebody who I've worked with many years together on a wide variety of projects. Great presenter. He's a great writer. If you've read any of his blog articles, if you haven't, you should go find them and read them. They're great. But Howard wanted to talk a little bit today about this return to work issue. So people are coming back to work. Employers are considering whether to bring people back, how to bring them back. There's a whole host of issues that go with this. And we wanted to give you a little bit of background and what we're hearing with our ear to the rail on these. So Howard, thanks a lot for joining us.
And thank you. And it's great to be presenting on this topic. It feels like after this long, endless era of darkness, the lights have come back on, and to even be talking about people coming back. And in my own personal life, this is the first week when my twin high schoolers are actually back in school each and every day of the week. And we happened to be talking about this as a family last night about what's going on, kids going back to school, parents going back to work, and the whole mood was different. It's upbeat, it's optimistic, at least until I happened to look down and right into the very sad and soulful eyes of my 9-month-old puppy, Bella. And Bella could not be more displeased about these trends of everyone going back to work. So before I get to what I need to talk about, I do want to ask all of you on behalf of Bella and other similarly situated COVID adopted dogs, that one trend to consider in bringing everyone back to work, at least this is her thought, is on-site doggy daycare. And I would imagine if anyone ever did that, you would be so flooded with resumes, you wouldn't be able to take it. Now I'm going to move on to the more realistic things that are going on in terms of bringing back people to work. And I certainly have had a lot of conversations with clients of different shapes and sizes about what they're doing. I've also been talking to friends and family who work for employers that have the audacity not to be bond clients, to get an idea of what's going on with them. And what we see is really clients looking at what fits their own culture and their unique workforce. So some clients are saying, the vaccine is out there, everyone back. And, maybe we won't start tomorrow, but we'll look at, let's say, July 1 or something like that, everyone back to work. Others are doing a more phased in approach. A friend's company is doing something where at least over the summer, and this is in New York City, they're gonna go back 2 days a week on this hybrid model. They're also doing something interesting where they're saying on the 3 days a week that you're not gonna be in the office, you still have to be within commuting distance of the employer. So what does that mean? So a lot of employees, when the remote started going full throttle, decided, well, I don't need to be in these parts, particularly around wintertime. I can do what I need to do at work, sitting in a beach chair in Florida with my laptop. So this employer is saying, everyone back in New York, everyone back in proximity in case we need you to come in. And then they're gonna go full back all in come September after the summer. So things that employers are weighing about this. And I think one thing to consider from the employee side of the equation is that working from home is just not a small little perk. For some people, it's very material to have that option. And I was talking to a human resources director, works in Manhattan, but is commuting in, and door to door, it's an hour to an hour and a half commute. She happens to have a toddler, and daycare is walking distance from her home. So on days where she is not coming into the city, she now has the ability to have breakfast with her toddler instead of running out the door trying to catch an early train, walking the toddler to daycare, coming home, picking up, and being actually able to have dinner with her child. And if work needed to be done, it can be done after hours. That is a material benefit to someone. And I think employers that have employees in that kind of situation, or you have people who now have the ability, if they're working from home, to watch their kids' Little League games or even coach a Little League team, that's material. So for some employees, if their employers just say, hey, that's it, everyone all back in, no exceptions, and they get a call from a recruiter for a company that does have that flexibility, there may be a loss of that employee. So those are things that need to be considered. On the other side of the equation, I see employers be very concerned that there has been a certain loss of creativity with people not being in the office. And for example, here in our office on Long Island, it is very common for people just to walk into each other's doors and run a problem by someone else. We also eat lunch together and kick around ideas. Now our clients are getting the benefit of combined decades of experience talking about a problem. It leads to a better solution. And that happens in most places of business where there's a focus now on team building, on group solutions, on creative thinking. And is that going to be lost if it's continued this people working from home and not being available for impromptu discussions? So I have seen some companies try to come up with some creative solutions here, whereby they'll have more formally scheduled Zoom meetings or Google Meets so they can have more regular communication to make sure that they're talking about ideas. I am also seeing a lot of impromptu Zoom meetings. So now it's become more and more common for when a client wants to talk to me, instead of doing it just a phone call, they'll set up a Zoom. That has a lot of advantages because we can share a screen and go over a document together and have that done. Now, the disadvantage to that, of course, is I have to dress like a real person every day and can't wear my 1980s concert t-shirts because I never know when the Zoom is going to come in. But I think that's a creative way of doing it. And I think for employers, there's got to be a real discussion about how do we balance all these issues. We don't want to lose our best employees to competitors that are offering flexibility that we're not, but we still want to have this kind of creative thought and this creative thinking. And I suspect that because remote working started before COVID, there was a trend of that before COVID. It just got accelerated by COVID. I'd like to think we're going to see a lot more in the way of these hybrid models, where you're going to allow employees to stay home on certain days, and other days you're going to say you really need to be here. So I think it's going to be a little bit of trial and error to get that down right. I do think for some employees, though, you may say, you know what, if you want to be fully remote, you can, but we can't have you be totally detached from your coworkers and from our company. You have to be part of us. And we're going to make you part of us by doing more regular check-ins and more regular meetings. So I know we are running over and I will stop there.
Howard, thanks a lot. That's great guidance. And I think it's something that, we all need to keep in our hats right now as we approach these changes. I should just add, Howard, you mentioned 1980s t-shirts. If memory serves, you are a fellow Rush fan, and
I
you
am.
have okay, all right, good. Hopefully,
much
one of
to
those
my-
t-shirts is a Rush one. There.
Yeah, much to my wife's pain and suffering.
Well, likewise, mine too. She sat through more conscious than she'd share. Great, thanks everybody. Here's the updates here. Here's the contact information. Again, we're on these things. We'll be in touch and see you all next week, hopefully. Thank you.